Hey everybody, welcome to 2019. Happy New Year. Crazy, hey? This is our Facebook Live number 11. I hope you're all enjoying the heat wave if you're tuning in New Zealand. Got a fair bit to cover today, so thanks for joining. Same rules, I guess, or principles apply. We are filming this live. You can ask questions on the Facebook app and we will answer them as best we can, and if we can't, we'll get back to you as soon as we can. If you are not able to watch the whole thing, we do record them. We put them up on Facebook, LinkedIn and YouTube, so you can watch them or go back over them if some things are not clear. You can also ask us questions after the fact. Just drop us a message through those platforms and we'll happily get back to you. So let's jump into it. It's a sort of a legal topic, Facebook Live today, so I'm going to do my best to keep it interesting because these can get pretty dry pretty quickly, but let's jump in, right? Because I think if 2018 was the year of the working group, 2019 is the year of change and implementation. So there's a lot scheduled. The government had their conference yesterday, I think, in the Wairarapa, maybe the day before, can't quite remember. And certainly the Prime Minister indicated that they were ready to act and take action. I noticed that the Fair Pay Working Group reported back recently, either this morning or last night. I heard Ian Lees-Galloway on national radio this morning being interviewed about it. I haven't had a chance to read it yet, but it covers a lot of the things that we thought it would, including the recommendation around fair pay agreements. So those are those agreements that govern industry bodies or industry groups, and every employer in that group is required to meet the standards specified in that agreement. It's a pretty retrograde step. They're called modern awards in Australia. We used to have them here a long time ago, quite restrictive, and I'm certainly not convinced that that will change maybe the view that we are a low wage economy. So keep an eye on that. I'm not going to dive into that one today because it's future legislation. The point of today is to talk about the changes that have come about, because it was about a year ago that we were talking about these potential changes, and we got a bit of pushback. Some people felt like they would never abolish trial periods and these sorts of things, but let's talk now about what has become law, because this stuff is going to affect you either immediately or very soon. So the first one is the minimum wage rise. If you haven't yet heard, the minimum wage for adults will increase to $17.70 on the 1st of April this year. So that's a 7.27% increase on the old minimum wage. So currently the minimum wage is $16.50. On the 1st of April, it will be $7.70. The youth wage, or starting of a training wage, that stays at 80% of the adult minimum, so that works out to be about $14.16. But most minimum wage workers by far will be on the new rate of $17.70. This translates to a full-time salary based on a 40-hour week of $36,816. So if you've had in the past a starting out salary of $35K, maybe for trainees or grads or something, that is going to have to change by 1 April as well. One thing I'm noticing is there continues to be a heap of case law around breaches to minimum standards, particularly relating to minimum wage standards. One recently, it cost the employer $188,500 for a range of breaches, including failing to pay the minimum wage. And it's amazing how often this seems to come up. The minimum wage is the absolute lowest. It is the floor. And let's be clear, it does not include annual leave. So your annual leave is accrued on top of your minimum wage. If you are a casual, it's the minimum wage plus the 8% pay as you go. The minimum wage does not include the employer's contribution to KiwiSaver. So you can deduct the 3% for the employee, but if the employer is contributing 3%, it's on top of the minimum wage. You cannot go below that $17.70 an hour. It's pretty clear in law, but based on the case law we're seeing and the feedback from the labour inspectors and the massive fines that are kicking around, not everybody is getting this right. So keep that top of mind, please. Don't forget too, the government has said that by April 2021, the minimum wage will be $20 an hour. So just in terms of your future planning, if we assume it's going to be an even increase between now and then, and I don't know, this is my speculation, but just to help you forecast and plan from a labour cost point of view, It will go up by, say, another $1.15 next year to $18.85, which is about 6.5%, and then it will be $1.15 the year after, and that will get it to $20.20. And that will obviously be a bit less than 6.5% because it's based on the new minimum. So I don't know what next year's min wage will be, but just be aware that we know that in April 2021 it'll be $20 an hour. At least that's the current signal. So that's all happening. 1st of April this year, it's going ahead. One other thing around this, I have covered this previously, both I think in a blog and on a Facebook Live, the topic of wage relativity. A lot of people, and I speak to clients who say, well, hey, I'm not a minimum wage employer, I don't have to worry about that. You know, we don't flip burgers or sell pizzas or whatever it may be. This assumption that sort of minimum wage, hospo, fast food type jobs. This will have an effect on wage relativity across the board. The minimum wage going up by 7% is a benchmark now potentially for future wage negotiations. And like I said, if you're a starting out worker who would normally maybe get a 35k salary, that's now below the minimum wage. Don't forget too, as the minimum wage gets closer to $20, a lot of people that you may employ might already be on that or close to that. A supervisor or 2IC person who may be on, say, 43k a year or $22 an hour, by the time the minimum wage gets to $20, their differential for all the extra responsibility they have won't really be enough to justify the extra work and the burden. You may find people saying, I don't really want the extra $30 a week less tax for all the extra work. I'll just go and do minimum wage work. So just be aware of that. Wage relativity is a thing across the board. It can affect you and us at all levels. So that's that one. Next, the Employment Relations Amendment Bill. So this is a fairly comprehensive set of amendments and changes to the current Employment Relations Act on the back of a range of those. I think, I can't remember what National called it, the Employment Standards Legislation Bill maybe was there one a couple of years ago, something like that anyway. So we're seeing changes and tinkering with the Employment Relations Act regularly, repeatedly, and by successive governments. As a business owner and a supporter of Kiwi businesses, I reckon it would be pretty nice if they just left it alone for a while and let us kind of get on and run our companies without having to constantly factor in changes to law. But anyway, that aside, we now have to factor in a whole bunch more changes. So there's a lot there, and two big topics are around the relationship with unions and the treatment of vulnerable workers. And I'm not going to cover those topics today because most of our audience and our clients either don't have collective agreements in place or fall into the vulnerable worker category. So there's just too much to cover without this Facebook Live going on and on and on for an hour and putting people to sleep. If you want to, or if you know anybody who is interested in learning more about the impact from a union and collective bargaining point of view and or the treatment of vulnerable workers, please let us know, message us, and we will run a Facebook Live specifically on this topic. And then tell your friends about it so everyone comes along and we can get some dialogue about these topics. So we won't cover those today. The three big things I'm covering, let's jump into the first one because this is effective immediately. It's law now because the Employment Relations Amendment Bill received royal assent on the 11th of December last year. And that is that effective from now, or from then, from 11th of December, reinstatement is now the primary remedy for a successful grievance for unfair dismissal. So what that means is if you dismiss somebody, either by sacking them through a misconduct or serious misconduct process, or making them redundant, or abandonment of employment, or any process that results in their termination, and they take a grievance for unfair dismissal and the Employment Relations Authority upholds that they have a legitimate grievance, the Employment Relations Authority must now consider reinstatement as a primary remedy over a cash payout. Now, I talked about this last year. I don't like this change. I think it creates a really dangerous sort of precedent for increasing payouts for employees is effectively what it's used for. When an employment relationship breaks down so completely that there has been a dismissal, if the dismissal is then upheld as being unfair, nobody really wants to come back to work at that point. But it can be used to threaten an employer and therefore the increase goes up. So in a mediation or sitting around a mediation table prior to the Employment Relations Authority, an employee can put forward their grievance and then simply say, I don't want any cash, I just want my job back. And an employer who realises they can't have this person back because they were terminated for legitimate reasons, there may have just been some procedural breaches along the way, and an employer who's now worried that they'd go through the Employment Relations Authority process and end up having to bring the person back in, suddenly the cost of settling that grievance goes up, and it creates this sort of bargaining culture in mediation, if you like. We've seen this before. This law used to be around. It's not particularly helpful. I don't know what problem it's trying to solve, but my opinions aside, you need to be aware of this. So what does it mean for you as employers? Well, it means you need to be really clear on your dismissal process and reasons. So do not shortcut process. As you know, and as we've said in previous sessions, the process is as important as the reason for the termination. So whether it's a restructure redundancy process or whether it's a dismissal for bad behaviour, misconduct, serious misconduct, there are steps and consultation processes and investigations you must follow. And you need to do that stuff now very clearly. And then the second piece, of course, is the substantive justification. So the reason why you were letting them go. So in the case of redundancy, it must be a commercial reason. Letting someone go because they're no good and you can't be bothered performance managing them, so you construct a commercial reason is very dangerous, particularly under this new change to the legislation. So that reason for the dismissal, be it a redundancy or again a misconduct thing, that needs to be very, very clearly understood and communicated when you go through the process. So that's now, it's effective immediately. So any termination processes you are currently involved in, I would suggest you just check or recheck to make sure you're okay with them, or give us a call if you have any concerns whatsoever. Now from 6th of May, two big things will come in to change. The first one is on breaks. So I'm going to cover that and we'll leave trial periods to last because a lot of people are asking us about trial periods. So from the 6th of May this year, there is a new and enforced structured breaks regime for all employees in New Zealand except for a handful of essential services. So again, I doubt any of our clients or the audience fits that category, so we're not going to even go there. I'm assuming that you all will be covered by this new breaks legislation. And the law now prescribes the breaks you must give employees, and it's simply this: for every or up to 2 hours of work, you do not have to provide a break. Between 2 hours and 4 hours, there must be one 10-minute paid break. Between 4 hours and 6 hours, there is one 10-minute paid break and one 30-minute unpaid break. Between 6 hours and 8 hours, there are two 10-minute paid breaks and one 30-minute unpaid break. This is just a return to the law we used to have. And I think I've said before on these sessions that we just advise clients in their employment agreements to say breaks will apply in accordance with the legislation, because breaks law is one of the biggest political footballs I have ever seen. It changes every time there's a new government, I think because they see it as something that's relatively easy to change. But anyway, we've gone from one system to another and back again here. So many of you may even still have this old regime still in place. But we're here now, which is where we used to be 9 or so years ago, maybe 6 years ago even. Prescribed and structured breaks. Now, you need to agree there needs to be agreement between the employer or the employee when those breaks occur on every shift. So whether that's through the rostering system, it might be written into the employment agreement, although I wouldn't really advise that, I've got to be honest, you don't want it to be that rigid, or just by verbal agreement or discussion at the start of the shift. But agreement needs to be made as far as this legislation is concerned, or this change to the law is concerned. If it's not, it prescribes to when those breaks might occur. So what it says is, for the paid 10-minute break, if you work between 2 and 4 hours, the break must fall in the middle of that period. For the 4 to 6 hour work schedule, your rest break occurs 1/3 of the way through, and the 30-minute unpaid meal break occurs 2/3 of the way through. For the 6 to 8 hours, the first rest break is halfway between the start of the shift and the meal break. The meal break is halfway between the shift, halfway through the whole shift, and the second paid break is halfway between the meal break and the end of the shift. Did you get all that? And then it repeats as you go from 8 hours, and then it's 8 to 10, 10 to 12, etc., etc. So the legislation tells you or your employees when they can take their breaks if you don't have agreement in place. So if you are a sort of hands-on critical environment, you know, retailers, factories, fast food, restaurants, hospi, bars, those sorts of things, where you need people either on the floor, on the machinery, or doing the work, on the phones, taking the calls, you would be wise to make sure you've got this buttoned down. If you have time and attendance or rostering software, it should allow you to schedule breaks into the rostered shifts. If it can't, you might want to think about different software, but I'm pretty sure any of the reputable or half decent ones would do this. So when you set the shift up for the employee, you set the breaks. That way you can stagger them. So you don't end up with your entire workforce walking off the shop floor at exactly the same time and leaving customers unattended to. Unless, of course, that's how you operate it, in which you shut down all machines, everybody takes a break and everybody comes back. Whichever category you fall in, you need to make sure you are agreeing on the break times, otherwise the law kicks in. So that's what this law says about breaks. Recommend you have a look at that. You've got until 6th of May to kick it off. Check your employment agreements too, because if you have more favourable terms, they will stay in force. The employment agreement here would trump the legislation because it's more favourable. It doesn't go the other way. If your agreement is less favourable, you have to raise up to the standards of law. So by more favourable, an example might be that I've seen 15-minute paid rest breaks instead of 10 minutes. If you have that written in your agreement, that stands. Sometimes the 30-minute meal break is paid and not unpaid. That might be written into the agreement. Sometimes the 30-minute break is provided as an hour meal break, and again may be paid. So if this is written into your employment agreement and agreed between you, your business and your employees, you have to stick to that. The change of this law does not give you an automatic right to change those breaks. If you want to change them in accordance with the law, you have to consult. So that's the breaks piece. Told you there was a lot to cover. Last one, so hopefully you're all still with me, and I've tried to make this interesting. I'm checking if we've got any questions coming through, but I think Esteban's just going to collate them and we'll go later, otherwise we'll be here all afternoon. There are people off camera if you're wondering, I'm not just sitting here talking to myself. So the last one, the loss of trial periods. I did have a few people last year say to me that this law would never go through, it wouldn't get over, why am I talking about it, why am I so concerned about it? Anyway, it is now law, and from the 6th of May this year, employers who employ 20 or more people will not be able to use the 90-day trial period. Employers who employ 19 or less will. So it's as we've talked about before, but I will go over the principles of this one more time. Really quickly, for those who are 19 and under, same as always. Trial period law itself has not changed. So this means you may dismiss somebody within their first 90 days of employment and they cannot take a grievance for unfair dismissal. Grievances for discrimination and disadvantage still apply. But the things to remember is there are, and have been for ages, really strict rules around the application of the trial period. It must be written in the employment agreement. The employment agreement must be signed before the person starts, before they start, not on their first day, before they turn up. They can't have worked for you before. They must have had a reasonable opportunity to review the agreement before they sign it and commence work with you. So if you're not ticking off these things, then the trial period may not be valid. And that's where we've seen most of the case law in relation to trial periods, is people have challenged the validity of their trial period. The Employment Relations Authority or the court have ruled that in fact, yes, it's not a valid trial because the agreement was incorrectly worded or the agreement was never properly signed, and they've thrown it out and the employees won the case. So be aware of that. If you're less than 20 staff, you still have some rules to follow and they are quite strict. 20 or more, you simply cannot use them. There's no provision for them. It does not apply. The way the law reads is it's the number of employees on the day the employment agreement is signed, I think, or employee starts. So when a person starts, they sign their employment agreement. The number of employees you have in your organisation at that time is what is counted. So where this gets a bit weird is if you have 19 people at the moment and person number 19 resigns, they might give you 4 weeks notice. You find someone in 2 weeks, which is pretty rare these days, but it does still happen. You might want to bring them on. They're available immediately to get 2 weeks handover. That individual will not have a trial period because they're person number 20. Now when person number 19 sees out the remainder of their 2 weeks notice and they leave, you now have this individual as person number 19, but you can't retrofit a trial period to them. You've missed the opportunity. So it's this group of 18 to 19 people, I think, that will be most affected by this in terms of daily ops, trying to figure out, well, do we just wait 2 weeks? Or do we benefit from a handover but give up the trial period? That will be a challenge. For those of you who are clearly over 20 and will not drop back to 20, you just don't have them anymore. Here's what we are recommending. We're recommending the return to the use of probationary periods. They are not as effective in terms of legal protection as a trial period, but we do still think they work when they are done right. And doing them right and improving your success across the board involves really 3 things. Improving your recruitment process. So we need to get back to good quality recruitment processes where we are limiting the number of poor decisions or limiting the number of idiots that get into the organisation. So we can't be lazy and high speed so much in our recruitment anymore, I'm afraid, because we have to make good quality, robust decisions. Get as many good people as possible into the organisation. Step 2 is a good quality induction and onboarding program. And that covers everything from the basics, like where's the fire escape, where's the toilet, what are the rules here, right through to the strict policies and requirements, training for the job, and support to do their job well. Within that induction period, managers will need to make sure they catch up with people regularly and give them feedback. So get a decent system that allows you to keep notes as you go through that time. Then that should vastly improve the rate of success, which is the main aim here, right? Hire good people and keep them for longer. Then the small number who don't make it, who don't achieve the level of success, or they don't fit in the way that you hope they would, or they're just plain disruptive, or they can't do the job, or whatever it may be, you can manage them through a probationary period. The advantage to the probationary period is it's a bit more flexible. You can make it 3 months, it might be 6 months. You can extend it if you want, which you can't do with a 90-day trial period. Provided you specify the rules of the probationary period in the employment agreement and the employee signs that agreement, those are the rules. So manage them through that process, and then if it doesn't work out at the end of 3 months or 8 weeks or 6 months, whatever you've put in, you can terminate them on notice, and they don't have to work out that notice period. Now, while you're not protected against an unfair dismissal grievance, the likelihood of a grievance being successful if you have done all of those things that well is greatly reduced. You're in a stronger position. You can still move on people who just don't work out. I know it sounds onerous. It certainly requires more process, more thinking than the old system, but it's not out of control. And if you do these things right, it's not as bad as it sounds. I know there's a lot of freaking out at the moment, but we've all worked for many, many, many years without trial periods. So it takes some adjustment. We've got until 6th of May to make those adjustments. We'll be working proactively with all of our clients who have more than 20 staff to get ready for this. If you need some help, get in touch. If you know anyone that might need some help, then put them in touch with us as well. In terms of what I think about the effects of this trial period change, again, we've heard heaps of speculation about companies downsizing to stay below the minimum. I think maybe companies on the threshold, someone with 18 or 17 staff, may think twice about jumping up, but if you're on a growth trajectory and you know that you'll go from 17 to 20 to 25 to 30 and beyond over the next few years, I don't see the trial period clause really affecting those growth decisions. It's a bit, if you consider growth in terms of millions of dollars, to not achieve that purely to avoid a trial period, I think is probably not what ambitious, smart entrepreneurs would do. So I'm not sure it's going to have that effect. I've heard some creative ideas like starting up a separate company where all new staff go and that company never goes over 20 and they work there, and then if they make it they get transferred to the big company. Pretty sure that's not going to fly, and I question whether the admin hassle and everything else around that is even worth it. You'd be better focusing on better quality recruitment, onboarding and managing of the probationary period, in my view. So yeah, let's not get too crazy or try and get too creative about this. If you're on the cusp, there are some things you can do. If you're carrying casuals on your books that haven't worked for you for ages, you can terminate them. If you are owners and you're on a PAYE salary, have a chat to your accountant. You might be better going onto a shareholder's salary and contracting to your own business. And all of these things reduce the number of employees in the business. So for those people around the threshold, that will help. For those of you who are big employers and will remain big employers, this is just about a shift in process. So that's certainly what we're recommending. And there it is, highly legal topic to kick off the new year. Thanks for joining me, and if you're watching this after the fact, thanks for tuning in. As I said earlier, please get in touch if you've got any questions. We'll be running these monthly. If there's demand, we might even increase them because we are getting a lot of questions now. But as always, reach out. We really like to hear from you, and thanks again. See you later.